Hi, everybody. Today we're covering the 2024 Oakland Adjustment Board update. And before we get into that, my name is Jeff Fowler, president of the Apartment Owners Association for over 40 years. And we've been serving housing providers like yourself. We have forums, and that's usually the main reason people join is for the forums and for the property management advice hotline that we have. And our goal is to help you make and or keep more money directly because of the services and the information that we provide you. And I do want to highlight the property management software that we have. We think that that will save you some time and streamline some of your property management processes. So hopefully you'll check that out. Go to the website, aoausa.com, and take a look at that. I know in Concord there's a referendum and they're still looking to gather signatures for that. And I know they're looking for people to stand in front of the Trader Joe's and the Walmarts and the different locations around town to find those registered voters for Concord. If would like any part of that, definitely you should get involved there. And if you email us, we can connect you, I believe. And on May 21st, we do have a landlording power conference. We did one up in Northern California. We're going to do one down in San Diego. We'll have 7 different speakers at that one. And that should be a neat time. During the summer, we kind of take a break from doing the in-person seminars, and we'll probably start back up in Oakland in August. And so without further, so here we go. Let's get into it. Our speaker today, he has over 30 years of experience. He's the founder of Beckman, Feller and Chang, and he is a real estate and landlord-tenant law attorney. And he represents the 7 counties in the Bay Area. And thankfully, we've had him contributing to the AOA legal Q&A monthly, and he's been doing that faithfully for almost 15 years now. And so it's really my pleasure to introduce to you Richard Beckman.
Thank you, Jeff. Appreciate that. And I think all that was true. I forgot it's been that long, actually. So it's been a good relationship, and glad to be part of it. Sorry I couldn't join you today and personally present this at the AOA office, but I am presenting remotely, and hopefully that will go well. We have Israel Pereira, who is our technical guru, who's going to make sure everything goes smoothly, but some things are beyond his control. So I am here to talk about some updates to the Oakland rental board's regulations that govern their rent control laws, and also to discuss the concept of their just cause ordinance. I mean, that area, most people who own rental property in Oakland should be well aware of. And I would just say as a preface that I would recommend to everyone that they go to the Oakland Rent Board's website, kind of routinely, because you can get updates. I think you can also get on their email mailing list, and you can get notifications of updates of seminars that they provide. And those seminars are probably well worth your time because they're so specific to Oakland. They're presented by members of the rent board or the Oakland tenant community. And I don't want to say know your enemy, but it's good to know what the other side is thinking about in terms of like how we can attack these. What new defenses we have. So they'll do both landlord seminars and tenant seminars, and I recommend that people who are involved in their own properties attend both. Again, they're usually for an hour, Wednesday evenings at 6:00, something like that. So that's information you can get when you go to the rent board's website. And then there's a ton of other stuff on there, links to all the actual laws, the ordinances, the regulations, a lot of forums that they use that they prefer practitioners, lawyers like myself use, or landlords if they're going to do it themselves. And if you use their forums, you generally can't go wrong. So when they're available, we recommend that you take advantage of them. So, and with that little introduction, I'm going to share my screen, hopefully, and show you a PowerPoint presentation that one of my associates prepared, and then we went over together. We learned some things together. So it's always a good opportunity for me to do these because I always learn something. So here we go. Sharing screen, which hopefully will be a PowerPoint presentation. And anybody can tell me if they're not seeing the Oakland Rental Adjustment Board 2024 update. I just got thumbs up from Jeff, so I think we're good. Okay. So yeah, this was supposed to be an in-person presentation at the Oakland Airport Holiday Inn, but I was requested to be in Los Angeles on a family matter. That's sort of late notice, and so I have to, which is where I am right now, Cypress Gardens. Anybody knows the neighborhood? But you're up north, so probably not. So hence the conversion of that in-person seminar to this streaming seminar. So, all right, and I don't know. I think it's probably time to update my photo, but about that later. All right, so I am now going to advance my slides, and here's how we do that. Hold on one second. I thought we'd gone through this, and there we are. I put that up there, and I put this here. Okay, good. All right, so there we have it. Thank you. The Zoom bar blocks some stuff. So this is the agenda. Overview of Oakland's rent adjustment program, what we call the RAP, highlighting new provisions, and a section on what constitutes just cause, and then an update on the regulations and what has changed. So, next slide. The rental adjustment program, and I don't want to have to just necessarily read what I've written, but it's an Oakland law that was first established in, I think, 1980, that establishes how much landlords can legally increase the rent charged to tenants. I mean, like every rent control law, that's what it does. It just puts a limit on what previously had been an unrestricted right of a landlord to set and increase the rent on their tenants. Who weren't already in a rental agreement. Because if you have a lease, for example, for a year, then that dictates what you can do in terms of a rent increase. Usually you can't increase it until that lease expires. But starting in 1979, really, with Berkeley, cities around the Bay and in Southern California as well, began to recognize that rents were increasing at a fairly drastic rate. And so people were being priced out of their homes. And it was similar to the concept of the Prop 13 when homeowners were getting property tax increases that were pricing elderly fixed income people out of the homes they'd owned for, decades. And so Prop 13 was passed to limit property tax increases to 2% of the value of the property, no more than 2% per year, regardless of the inflationary impact. So rent control operates much the same way. As long as you stay in your home, whether it be the home you own for Prop 13 purposes or the apartment you rent for rent control purposes, you're not subject to wild rent increases based on the cost of living or the landlord's, needs. Like, hey, I need to make more money from this property. So starting in 79, like I say, and then Oakland in 1980, rent control came to be. And it just says you can only raise the rent a certain amount, usually based on the consumer price index. I was just talking to Jeff about this because we talked about some other local ordinances that are in the Bay Area coming up, and it's pretty much everywhere. Because as most people know, in 2019, the state of California passed its first statewide rent and eviction control law, AB 1482, the Tenant Protection Act. And that, for the first time, imposed these concepts, rent control and eviction control, across the state. So most of the local jurisdictions that didn't already have rent control, which were mostly the places outside the major cities, were covered. Although some of them have, like Concord, Jeff was mentioning that, a few towns in Marin, where I live, are enacting their own local versions. And basically, they seem to be kind of a compromise between the state version. In terms of rent control, the state is a pretty lenient rent control. It allows owners to increase the rent 5% plus the cost of living. And if the cost up to a maximum of 10%, and I think that's what it was last year when inflation was running, CPI was like 8%, 7%, whatever it was. That combined with the 5% that allows for a profit increase, resulted in 10% rent increases to tenants subject to the state law. Conversely, the local ordinances, particularly the more stringent versions like Oakland, Berkeley, and San Francisco, they limit rent increases, excuse me, to a percentage of the consumer price index, usually about 60%. Now, so that in that respect, you can't even keep up as an owner. You're not even allowed to keep up with inflation in terms of the rent. And so these local ordinances in the smaller jurisdictions, like just what happened in San Anselmo in Marin County and Larkspur, they kind of cut a middle ground. They basically allow rent increase to be the amount of the inflation rate, this consumer price index. So they don't allow, like the state law, the 5%, which increases your profit on that unit, but you don't fall behind at least. And so it seems like, I mean, not politically, I just stay neutral, but it's, seems like a reasonable compromise in terms of not the sort of the really stringent versions in Oakland and Berkeley and San Francisco and some other places. So that's the basic heart of the wrap, and it is not the just cause ordinance. It's important to understand that at least in Oakland, other places, the rent control provision and the eviction control provision are in the same law. In Oakland, they were actually passed at different times, so they're really two separate sets of ordinances, and they can be found easily at the Oakland Municipal Code. Which online, it's just so great. You can go to the Oakland Municipal Code and you can read, both ordinances. To the extent there's any interest in doing that, but it is the law, and it's the best place to get information rather than hearing it from somebody or something. So we're going to talk about both, but right now I'm just speaking about the rental adjustment program, the eviction, the rent control provision. I don't need to say it was adopted in 1980, and this is a talking point from the rent board that it was about concerns about rising rents and so on. Designed to regulate rent increases, provide certain protection. Yes, absolutely. So basically, you start from the provision that it applies to every unit that's rented in Oakland, all residential rental units, and then there are exempts. When it says partially exempt, what we're talking about here is some units can be exempt from rent control. I don't know if you see my cursor, but I've tried to italicize that, but not eviction control. And eviction control is the just cause requirement we're going to talk about in a little bit, but it's important to know that you can be exempt from one and not the other. Usually exempt from rent control, but not eviction control. And there's a category, and you can go to the rent board's website or the Oakland Municipal Code and get the details. This is kind of a summary. Basically, units whose rents are controlled by another agency like Oakland Housing Authority, Section 8 program or other federal rent subsidy programs are not subject to the Oakland rent control. Traditional, various non-traditional housing, motels, hotels, tourist houses, boarding houses, and then provided that you haven't been there for more than 30 days, then you turn into a protected tenant, the tenant subject to the rental, the rent control law, and cooperative units. And then for most people's, day-to-day concerns, single-family homes and condominiums are exempt, and that's due to a state law called the Costa-Hawkins Act. So, and they're not always, because if the previous tenancy was terminated for something the tenant didn't do, then the next unit does not get the benefit of being able to set the new rent. So that's a little bit of a complication. But generally speaking, single-family residences, single-family homes and condominiums are exempt. And it's important to note, though, that in the single-family residence context, a lot of people think they have a single family home, but then upon further questioning, you find out they have a little in-law downstairs that takes it out of the single family home. And so the whole building is subject to rent control. So important to always be aware that if you put a little in-law down there, you've removed yourself from that exemption. And let's see, this is, so again, my little Zoom bar is blocking some of my screen, hopefully not yours. The business license requirement, because in Oakland, in order to have rental property and to be in compliance with all the things that you need to do if you ever need to take action, you got to have a business license, and there's some consequences if you don't. There's the rent adjustment program fee. You got to pay that, but you can pass half that on to the tenants. And my assistant Sybil was kind enough to provide links to all of these points, at least most of them. So you could, anybody who wants a copy of this PowerPoint presentation can reach out to AOA regional managers, Allison Carnes, and I will send it to her or to the mothership down in Southern California, and they can send it out to anybody who wants a copy. And then this should link to these specific places where this information comes from, because we don't make it up, we get it from someplace else. And so I think it's nice to have that, what we call the source material, handy for anybody who wants to really see it. And I recommend that. That's a good idea. Business license fees continued. Consequence of failing to pay the fee. Well, I'm not going to go into this too much, but failing to have your, pay your registration fee, the program fee, can affect your ability to participate in rent board proceedings and rent increase petitions. Now, actually, funny enough, one of the changes that happened, well, we're going to talk about in the rent adjustment program regulations. They used to have very specific provisions that your filing is not considered complete until you do all these things. Provide us information that your business license, that you're compliant with the registration fee and all that stuff. They now amended that to just say, basically, when all your stuff is ready, then you're ready to go. But they don't tell you what it is anymore. So I don't know that that's an improvement, quite honestly, because when they list it, it's easier to figure out. Let's see, the rent registry. We talked about that on a few of these seminars, and certainly covered in some of the question and answers in the magazine. But the Oakland County City Council adopted a requirement that establish a rent registry. So basically, you got to go to the rent board's website and register your units. And there's some forms there. I mean, I presume I haven't done it because I don't have property in Oakland, but I presume it's pretty self-explanatory. It began that your first had deadline was by July 3rd of last year, and then it was supposed to be of March 1st of the preceding year, but this year you have until July 1st, and that's because, as they explained it, there was just too much information for the rent board staff to process, and so they just said, "Wow, we need more time," and so they extended the reporting deadline to July 1st of this year. After that, it's going to go back to March 1st. And well, hopefully they'll be caught up by that, but who knows? And this certificate of exemptions. So this is basically a document that the rent board will issue that confirms that your unit, for one reason or another, is exempt from the regulations and the rental adjustment program ordinance. This is probably most necessary for new construction, which is basically buildings built after 1983. So permanently exempt from the rent adjustment would be, and we're going to talk about the exemptions in just a minute. And I'm just reading because Sybil copied this from their press release. They don't issue certificates of exemption for single family homes any longer. I think you used to have to, before you could do an unlimited rent increase because it was a single family home and exempt from rent control, you had to get a certificate of exemption from the rent board. It wasn't ever really 100% clear, but I always advised clients, hey, if you're exempt, might as well get the notice, the certificate of exemption, because you can wave that around and you never have to deal with it again. So now they're just basically saying we're not issuing those for single family homes anymore because they might change their character. I don't know, build an in-law, and then they're no longer exempt. So that's basically the thinking there. But again, if you like the information, the links should take you to it. But in most cases, single family homes and condominiums will still be exempt from the rent adjustment program. And here's your annual cap. So the RAP imposes an annual cap on rent increases for the covered rental units. It's 60% of the CPI or 3%, whichever is lower. So yeah, when inflation was running at 8 or 9%, but it's pretty rare that 60% of the CPI is not going to be 3%. But so effective August 1st, the last one, the CPI was only 2.5%. So 60%, you can do the math. So inflation was running about 4.5%, something like that. Allowed rent increases and petition process. Landlords may petition for rent increases above the annual cap under certain circumstances, such as capital improvements or increased operating expenses. For example, if you have to put a new roof on your property, you can petition for a rent increase, and that's called the capital improvement increase. You can ask the rent board and give them documents as to what it costs and so on, and then the rent board presumably will agree and say, okay, and then they amortize the cost of that expense over, I think, 10 years, depends on what it is, 5 to 10 years. And then you are allowed to pass that cost on in the form of a sort of an extraordinary rent increase to the tenants. And again, more information regarding filing that petition is available there at the link. So this is a pretty important to be aware of, the notice of the RAP program. I think a lot of what we fondly refer to as mom and pop property owners probably just aren't very aware of some of these things. But if you don't do these things, there can be, not, they're not fatal consequences, but they can mess you up a little bit, maybe even more than a little bit. But you have to give the tenants a copy of the RAP program. It's basically a RAP notice, and the rent board has it. It has to be in 3 languages. You have to give it at the commencement of the tenancy. And if you didn't give it at the commencement of a tenancy, which a lot of people like to say, the smaller property owners, the bigger property managed companies, they know these things and they're on top of it. But if you didn't give it at the beginning, you got to just give it any time, sooner than later would be the rule. But you have to give it with every notice of rent increase and change in terms of tenancy, because if you don't, both of those will be defective. Like if you haven't given the RAP, even if you gave it at the beginning of the tenancy, but you don't give it with the notice of rent increase, that rent increase will not be effective. So it's really important that you know about that and then that you comply with it. So yeah, important in providing it. It's crucial for compliance. For if I provide notices, challenges to rent increases and eviction. Yeah. Oh, and you got to make sure you have proof of giving the notice. When filing an owner's response, the owner must submit evidence that the owner has given the notice. And this is generally done by something called a proof of service. And AOA has the forms. I mean, all of their notices include sort of attached to it a proof of service. But you just need a document that you can get online, a California Judicial Council form. And here's something worth noting. I probably should have put this in, but just now, Chris. You can go online to the Judicial Council of California. You just type in California Judicial Council. And that's like, Council of Elders, not Attorney Council, but spelled different. Synonyms, yeah. And they have a lot of Judicial Council forms, which are approved by the state, judiciary. So they're, infallible, so to speak. And their proof of service just basically says, this is what I did. I'm under penalty of perjury. I mailed a copy, or I delivered a copy, or I posted a copy. And this is when I did it. And then that's your proof of service, because otherwise you're just going to be saying, oh yeah, I'm pretty sure I did that. So just anytime you do stuff, just prepare a proof of service. It's a great memento, and it's very persuasive, and much better than just trying to remember or looking at an email that, oh, I think I sent that. So proof of service, very important. So that is the overview of the rental adjustment program, the control part of the sort of hand in glove ordinance called the rent control laws. Now we're going to just quickly turn to the just cause for eviction ordinance. So as my little notes point out, in 2003, Oakland voters narrowly, I think it was like 50.5%. I don't recall exactly, but my recollection, because I think I was living in Oakland at the time, said it was narrowly approved. But basically, it was a copy of San Francisco's ordinance that tenant activists put on the ballot, and Oakland voters approved it. Measure EE, also called the Just Cause for Eviction Ordinance. And that OMC is the Oakland Municipal Code. And again, you can go on to the Oakland Municipal Code website, and you can find all these ordinances, and you can find the exact language and so on. So again, a good thing to know about, whether you ever go there or not. And just cause refers to the specific reasons that allow a property owner to evict a tenant. The reasons are broken down into 2 categories, really. There's either no fault or at fault, and they're kind of just like they sound, but at fault are things that the tenant has done wrong, basically, and has failed to rectify or cure, as we say, 3-day notice to cure or quit. And it's, the things you would be, pretty obvious. Failure to pay the rent, material violation of the rental agreement. The material was added in the changes recently in Oakland. Even though it's always been state law, it has to be a material violation. And what's a trivial violation? I mean, trying to think of something like you can't let the grass grow more than 6 inches tall. Let's just say, well, it's 7 inches tall. I know it's a silly example, but it's got to be something that really is significant enough to justify terminating somebody's tenancy. So court looks at it pretty seriously. Like, yeah, material means something that justifies making somebody move out of their house. Causing substantial damage, that usually qualifies. And the tenant continues to disturb the peace and quiet of other, that's basically being a nuisance. And all of these require a certain amount of notice to the tenant. Some require 7 days, what we call pre-notice notice, because historically you just would serve a 3-day notice to a tenant to stop doing whatever it is they're doing. And if they don't, you can file an unlawful detainer. And Oakland started this, I think, as far as I know, creating in like 2007, thereabouts, 2006, something called the pre-notice requirement, which means you have to give the tenant a pre-notice before you can do the state 3-day notice. And depending on what the activity is, it's usually a 7-day notice. If it's something that is really involving public health and safety, it's a 24-hour notice. But in every case that I know of, you have to give a pre-notice notice before you can serve the formal 3-day notice that, again, tells them to stop doing that or get out. So it's, I don't know, stop being annoyed by it. We just do it. Engaging in unlawful activity, and that's defined, drug sales. Running a house of prostitution. Unlawful activity, it encompasses a lot of things. And this is a good one, actually. Just refusing to allow property owners access, because as most of you know, there's a civil code, state civil code section 1954 that governs when owners have the right to enter a rented property. And it's for making repairs, to respond to requests for repairs, to do inspections if there's indication that it's necessary, to bring in experts, contractors, agents to view the place. There's a list, Civil Code Section 1954. But tenants don't always comply when you give them the notice. They're like, "I'm not going to be home. Don't go in," or "I'm here, but I don't want you to come in." Owners have showed up with their vendors and made a lot of arrangements, and it can be very frustrating. One of the stupider disputes I come across between landlords and tenants. It's like, unless the tenant is just out of their mind, or the landlord is just completely violating, the tenant's rights of privacy and so on, this should not be a controversial thing. It's like, "Hey, I need to come in and do some work. You've complained about the heat," or whatever the case may be, or "I got a report of a leak from downstairs. I need to come in and check. And here's when I plan to do it." And, if the tenant says, "Well, I'm not there, I'd like to be there, and I can be there at this time," we try to work it out, but it was never clearly set forth, certainly in Berkeley or San Francisco, as a just cause ground to terminate the tenancy if the tenant absolutely refused. Oakland allows it, and it's a just cause ground. So I give them credit for that one. And then the no fault category, just really a couple. And this basically, again, refers to situations where the tenant has not done anything wrong. If the landlord is acting unilaterally because they have as I say, a valid reason to terminate the tenancy under the ordinance. And the basic, most primary ones are owner move-in. Now, that's kind of broken down into 2 categories, and it's kind of important to know because it can make a huge difference. So the unit was your principal residence and you rented it, but you rented it and you included in your agreement that you have the right to come back and reoccupy with proper notice. Now, if you do that, you have taken yourself out of the sort of second category of owner move-in, which is you didn't do that, but you want to move in, whether you just bought it or whether you've owned it for a while and you just decided you want to move into it now, or you have a relative that wants to move in. That's the classic owner move-in slash, qualified relative move-in. But that process requires paying relocation fees that can be, tens of thousands of dollars. It depends on the size of the unit in Oakland and how long people have been there. But relocation fees have gotten quite significant in the last, few decade or so. And you put restrictions on your property. If you rent it out again in the next 3 years, you have to offer it back to the people that you rented it, that were renting it before at the same rent they paid before, plus the regular increases you could have done under the wrap. And there's, I think, a recorded restriction on that fact. So, the owner move-in is a much more involved process than this first one, which is to say you previously lived there, you rented it out, and you kept a little provision in your rental agreement that says I have the right to return. So if you're somebody who owns your own property and you want to move away for a while, rent it out, make sure you include this provision that you have the right to come back. Because then all you have to do is give a 60-day notice of termination if they've been there more than a year. But you don't have to pay any relocation fees. You don't have to go through all of the commitment of being there 3 years, all that stuff. So that's a really important distinction to know. And then the owner this is the Ellis Act. This is the other, basic where the owners just decided to go out of the rental business entirely for all the units that are on any given parcel. And the Ellis Act, that's a state law. It's it's pretty well known. There are two state laws that every property owner that rents probably knows: the Costa-Hawkins Act and the Ellis Act. So the Costa-Hawkins Act, though, is under attack. I don't think the Ellis Act is. It was just basically a law that codified the right of an owner to go out of business. You don't have to have a reason. You can even be angry at your tenants. It could almost even be for discrimination, but there just is no defense to it. Now, tenants might be able to sue if it's really proven that you were discriminating against them because of some protected category they fall under, or retaliating against them for something they've done, but it's not a defense to the unlawful detainer. So it's pretty much, as long as the attorney gets the documents right, the paperwork right, and that's challenging. And tenants who are a certain age or qualify as disabled, and it's a very, very low bar. Anything that, any life activity that is significantly impaired. And I don't know, it just seems like almost everybody can make that statement. They get a year notice. So the Ellis Act notice, unlike regular termination notices, which are 30 days for people that have been there less than a year, 60 days for people that have been there over a year, the Ellis Act is a 120-day notice. But if somebody claims this additional time, additional 8 months by age or disability, then they get a total of a year. So if the attorney, or the owner doing it himself, herself, somehow screws up the documentation part, then if the tenant catches that, and tenants' attorneys are quite good at catching things, then it'll be thrown out and you start all over. So that's a really it's really tricky ground to proceed on, just because of the length of the notice, and if you don't get it right, the consequence of having to start all over. And just note: sale of property, expiration of lease, foreclosure property, changes in the federal Section 8 status of a unit, not just cause. So just only things that are specifically listed as just causes in the ordinance qualify. So exemptions from just cause. And I'm trying to think, did we do the exemptions from the wrap? Because it's basically, in addition to single family homes and condominiums, new construction, but new construction under the wrap program is a property built after 1983. So, because all of the ordinances, San Francisco, Berkeley, Oakland, all had provisions that it was an enticement to the developing community to not get in the way of passing these laws by saying new construction will not be covered. And so, developers were not going to be dissuaded from building new properties because they were going to build under rent control. They're like, why would I do that? So that was a compromise that was in every one of these ordinances, that anything built after the passage of the ordinance itself would just not be subject to it. And that was the way it went for a long, long time. And then I guess because, like in San Francisco, the rent control law was passed in 1979. Measure EE was 2003, so not so long ago. But eventually, more properties were becoming exempt because they were, new construction and they were 50 years old. And so San Francisco changed it, and Oakland has now changed it, I think, by voter amendment. And now it's 10 years. Anything built within the last 10 years is exempt. Um, and that's exempt fully from just cause and from rent control. So that was, a little bit of a, for people who own property that was exempt and now suddenly you're not exempt. That I have clients all the time who complain about rent control, and I simply say, look, if you bought into rent control, you know, you can't complain because you knew what you were getting. But people who had it thrust upon them by changes, yeah, I can see where they'd be a little distraught because it is a kind of a big deal. And this is probably one of the bigger changes. Um, Another way that you could have, and not many people actually did this, but still it was an option, if you substantially rehabilitated your property, meaning you really kind of gutted it and rebuilt it, that would get it exempt from rent and eviction control. But that's been removed as part of these regulation amendments that just took effect. And I'm going to make a little note. I was talking to Jeff earlier. The subject was regulations, amended regulations for the RAP program. But there was, and that happened in December of 2023. That the city council passed an ordinance, well, a resolution to amend the RAP ordinance and the regulations to it. But there was other amendments to regulations, but they were specific to the just cause section of the law. And there was a lot of confusion about which was which. And in some cases, it doesn't necessarily matter as long as you are aware of it. But basically, the substantial rehabilitation exemption no longer applies. So I don't know if people are going to be motivated. I don't know why they felt like this was a good idea. Well, let's see. Prior law allowed such parties to be exempt substantially, in order to qualify. It had to be completed within a 2-year period. Yeah, but they're no longer. They are no longer allowed to exempt substantial rehabilitated properties. And I just want to mention the CPI and banking rent increases. And this gets a little in the weeds. There's something called bank rent increases, and that's where if you don't, if you don't impose a rent increase annually, as you're allowed to do, you don't lose that rent increase. You have the right to impose it later, and that's called a banked rent increase. And it's funny, I don't know about funny, but the state version, the Tenant Protection Act, the AB 1482, doesn't actually have that. So if you don't do a rent increase, if you're covered by the state law and not a local law, and if you don't do the rent increase any particular year, you don't get the right to do it later. So in that respect, the local ordinances are a little more favorable than the state version because you have the right to bank rent increases. In San Francisco, for example, you can do it all at once. And I have clients who just didn't really stay on top of things, and they go, "Oh yeah, I've done a rent increase 10 years or something." I'm like, okay, well, here's the list of permitted rent increases each year. You add them up, it might be 25%, 30%, and you can do that all at once, which can be quite a adjustment for the tenant. Oakland took a slightly different tack and said basically you can do your bank rent increases, but cumulatively you can't do more than a 10% increase per year. And so you might have to do, a bank rent increase of 10% with 2 or 3 or 4 years to finally recapture all the increases that you could have done but failed to take. And this basically talks about landlords who do rent increases but don't do the entire CPI adjustment amount. I don't know anybody that would do that. I mean, okay, you're entitled to 2%. Well, I'm just going to do a 1% increase. I guess there are property owners who would do that because they want to not impose a bigger increase on their tenants. But and I'm not sure. I think those were not. You couldn't capture those if you didn't do the full amount. Each year. If you didn't do any increase, you could keep it and use it later. But if you only did a partial increase, you didn't get to add that to your banking. So I hope that makes sense. So yeah, including the total increase cannot exceed 3 times the CPI or 10%. Pretty sure that's still in there. Yeah, 3 times the current allowable CPI or 10%, whichever is lower. Yeah. So CPI and other rent increases. So bank rent increases can be combined with other rent justifications. And I'm not sure what those are because increased housing services and fair return are pretty much, well, so a bank rent increase can be included, for example, with a capital improvement increase. Because again, there's only a very small number of allowed rent increases that are not CPI related. So I'm going to say that about the only one you can include with the bank rent increase would be a capital improvement. Any bank rent increase must be implemented within 10 years. That's new. I don't think there was a timeline before. So if you're gonna capture your rent increases, make sure you don't wait too long. So the housing service increase can't be done in the same year as the CPI because it replaces the CPI increase. So if you go and you get a petition for increased housing services, and I don't know, that's like increased utility costs, mortgage servicing. Like if you're, and in fact, that's a good question, and I got to say I'm not exactly sure if I have the answer because anybody who has an adjustable rate mortgage has felt the effect of the inflation increases in the last year. I mean, speaking from experience, a line of credit, with an adjustable rate, like the payment doubled without any increase in the principal. So if you have, $1 million mortgage or, whatever, and it's got an adjustable rate provision and you were paying 4% or 3%, that's now gone up to 8%, your monthly payment has increased significantly. And I believe that is a housing service cost. Property tax increase or not. But your mortgage interest rate, I believe, is, but easily answered. I just don't have it at the top of my head or the tip of my fingertips. All right, so other updates. These are really related to rent board petitions, either those filed by the landlord or those filed by the tenant. It's not something of significance, I don't think, for today. But basically, it sort of removed some of the specific restrictions. I mean, one of the big ones was, well, before, if you didn't appear, it would just be dismissed. Now, if you don't appear, when this is for an appeal from a rent board decision, the hearing officer can go ahead and make a decision at their discretion. But like the parties can no longer mutually agree to an appeal hearing postponement. I mean, okay, that's a change, but how significant is that for most of us on our daily lives? Not so much. We talked about that. The rent registration deadline was extended from March 1st to July 1st. The this one is kind of interesting, and this is pretty, I think this one's pretty important. The rent adjustment ordinance that deleted the requirement that the tenant be current on their rent or lawfully withholding it to file or respond to a petition to the rent board. I thought that was, it's like skin in the game. All right, if you want our help, you got to make sure you're in compliance. So a little surprised to see that. And it's possible that the rent board just decided that this lawfully withholding meant they had to have a determination of that before they could even decide if the tenant was able to file or respond to a petition. So they just said, forget about that. That's just too much sort of pre-adjudication for us. We just, we just remove that requirement. I'm guessing is the thinking there. And that just the prior law just refers to that, basically. Tenant had to swear under oath that they were current in their rent or lawfully withholding. I mean, it's good that they do certain things like, confirm a deadline for things like for tenants who seek a decrease in housing services. That kind of petition can only go back 3 years. Yeah, I'm not sure if it was unclear before, but it's nice when the powers that be, make it black and white. It just means it's one less thing to fight about. Because anytime there is uncertainty, either in the law or the facts, it ends up costing people money because they got to argue about it. They usually hire lawyers to argue about it, and there you go. And then plus, of course, there's the uncertainty of the result. So it's just nice when when the I'll say the powers that be, make it clear so there's nothing to fight about there. Um, I don't care about that. The property owner may show evidence of exemption from the rent program fee as an alternative to showing evidence of payment of the fee. Okay. And again, this was, my assistant. I just said, yeah, we're doing a seminar on updates to the regulations. So I went through it with her, and I'm like, it's a little more than they probably need to know, but it's there. And again, you can get a copy of this if you want to look at it in more detail. Now, this is pretty significant, particularly for people who do their own Oakland termination notices, whether it be 30 or 60 or 3-day notices. And this isn't and this is what I was talking to Jeff about. This was the confusion between there was amendments in December to the rental adjustment program, and the amendments in February to the Measure EE just cause ordinance. So even though this talks about the rent adjustment program, this was the amendment to the just cause, and it basically says that any notice has to have this language from here on down. Oh, sorry. Oakland has a number of laws. This language and no other apparently will be sufficient after February 24th to constitute a valid notice of termination. And AOA, of course, has updated all of its notices. But if you do your own and you have your own, you got to make sure this language is in there, or you will almost certainly get dismissed and have to start all over. So that is a word to the wise. And I'm not sure why we wanted to make changes. Changes to the Ellis Act ordinance. We talked about the Ellis. That's one of the just causes. And so if you do use the Ellis Act, you're restrained for certain periods from doing certain things. 2 years from renting out at all. For 5 years, you're restricted to the amount that you can charge, which was the same amount that you charged the previous people. And for 10 years, you had to still offer to the prior tenants, even though at market rate. So I'm not sure how important that is. So now the amendment makes it clear that this time frame is defined by the date that the units are withdrawn, not the date that the notice was filed with the rent program. So I'm not sure there was confusion about that, but again, anytime you can, amend an ordinance to make it more clear for the people that have to rely on it, that's a good thing. So now you know that 2, 5, and 10-year period starts from the day that you actually withdraw the units, which is the termination date of your notice, not the day you file the notice with the rent program. Apparently it's time for questions, so I'm going to stop sharing. And wait, that's me. Thank you. If you have anybody wants it, et cetera, et cetera. So, okay. I've been talking for quite a while. I hope people are still with us. It's not easy to just hear a droning voice for however long it's been, but.
Well, thank you. Thank you very much for that. So now if you do have a question, and
yes, it goes in the chat room.
Yeah. Are you okay there, Richard?
I see a chat message sent or posted in a meeting group chat. I got it. Looks good. Oh, somebody said looks good, I guess.
Oh, yeah. Yeah, you're good. We're all good. All right. So now if you're watching on AOAUSA.com, there's a blue help button on the bottom right side. You can put your question in there, or just into YouTube. You can put your question in Facebook, put it in, and they'll get that over to me. And yeah, then we can answer any of those questions that you have. And
it looks like I've got a few extra minutes.
Yeah. Was there other comment that you had, Rich, that you're wanting to make? No, okay. No, I just thought maybe, I didn't know if what you just said there meant that there was something that you wanted to add or not.
Oh, no, I think I was just, when you and I were talking, it was about, the difference between the RAP regulation amendments, which is what this was about, and the just cause amendments that passed in February, which I think a lot of people had confusion about, and we're kind of conflating the two together. So ultimately, it's being aware of the distinction is probably the most important thing.
Okay, great. Yes. Yeah, and it's there's so many different little things that can be going on, so it's important to be aware of all of it.
The big one is that notice language. That
Yeah,
is, of anything else that we've talked about today, I would say that would be the most important thing to be aware of if you do your own notices. You can't
right.
use old notices. You just can't. After February, throw them away, because they're just no longer going to do the trick. And then that other thing about if you live in your property and you do decide to leave for a while and want to rent it out, make sure your lease includes this language that gives you the right to return, which will just avoid all the hassle that goes into an owner move-in tenancy termination. So, and you
Right.
don't pay relocation fees.
So we'll take questions about the Oakland ordinance here, and we can also take questions about just regular California state.
Yeah, I mean, certainly I should be conversant on more than just the Oakland rent regulation. So.
Yeah. So here we go from Michael. What is the rule for raising the rent to market after voluntary vacancy, or any vacancy really for that matter?
Well, so this is part of the Costa-Hawkins concept, and sort of just a brief history lesson. Berkeley's rent control law was the only one, I think, in the state that had what was called vacancy control, which meant that even when a tenant moves out, the rent board would set the rent for the new tenant. And people consider that to be just more government regulation than they could justify or handle. So people got together, convinced a assembly member or a California Senate, I forget, Mr. Costa or Mrs. Costa and Mr. Hawkins or Mrs. Hawkins to sponsor a bill that said under no circumstances can a city impose vacancy control. They were basically aiming it at Berkeley, but to dissuade any others who might be thinking about it. So that was a big part of Costa-Hawkins. They also exempted rent control from any property built after 1996. Another big part. Now, it's the Costa-Hawkins Act that's under fire every year by tenant advocates, and I'm sure AOA will send an occasional flyer out because there's a ballot measure. I think it failed last year but enough persuasion, enough money, enough packaging, enough artful. I don't want to say propaganda, but depending on how these things are presented, it could easily pass. But to the question, once a tenant moves out, the landlord has the right to set the rent at market rate. There are a few exceptions. If you're in a rent-controlled jurisdiction like Berkeley or Oakland or San Francisco, and you made the tenant move out through a change of terms of tenancy that made the tenancy less attractive, or you terminated the tenancy for owner movement or something like that, there are restrictions on your right to set the rent to a subsequent tenant. So, and that's a little complicated of a concept to discuss right here, but generally speaking, when you have a new tenancy, you're free to set the rent at market rate, no matter where you are or where your property is located.
Right. Yeah. And there's been two other times when they've gathered enough signatures to get it on the ballot to repeal Costa-Hawkins. And even that little yard sign that I have there behind me is an example of what we did. And we mailed those out to every single member. At whoever was current at that time, they got that and they were able to put that up in their yard. Excuse me. And also,
so last November, that was the Prop 10.
Yeah, 20. I think that was was it 22 maybe?
Okay. Some things I keep track of, some things I don't. Old props that didn't pass, I don't.
Right. And so it's going to be on the November ballot again. And right now it's currently known as Justice for Renters. Not really
packaging.
And again, that's packaging. So the packaging is no good if once they put a number on it, we'll really have to hope for the very best description, an honest description of that thing. And
I mean, the voter guides, the state Secretary of State, puts out a neutral, but who reads that? I do.
But let's see how neutral it is. But basically,
generally speaking, they do the pros, the cons. I mean, the voter package that you get, the little booklet. Again, I mean, how many people actually take the time to read that? I mean, but it's there. So, the information is there if you want to get informed. Otherwise, you just get influenced by whatever ad you see that day.
Right. And so since people don't read that much, and since people easily could vote a way that they really don't want to vote, we highly recommend
Well,
these yard signs that we're going to do. And enough for you and enough for as many properties as you have. That obviously costs money. It's about, last time we did it was about $15. It's probably, with inflation the way that it is, it will have gone up further. But we want to be able to provide that for everybody. So we
yeah.
are asking people to give to the AOA Political Action Committee so that we can mass produce those and get as many as you need. And really, we need everybody to talk it up with their friends, to put those out as much as possible so that people really understand what it is, and understand that it's bad for renters and it's bad for
That
owners as well.
I don't know about so much, but I mean, I think of the Prop 19 that passed, 2 years ago, that took effect in just a year ago, February of last year, that basically removed the exemption from property tax reassessment when you pass property down to your children, either by inheritance or otherwise. And I think from what I've seen anecdotally and specifically, people didn't realize that. And so when people started to realize they now their family home, which is now being inherited by their children, is going to be reassessed at current value, which will raise the property tax 3, 5, 10%, 10 times. I mean, and they're like, I can't, I have to sell the family home because I can't pay the property tax. I mean, there's a lot of buyer's remorse, whichever it is, over Prop 19. So yeah, I mean, it's important that people understand exactly what is being proposed in these
Yeah, so
propositions.
we're really taking this one seriously, and we hope you do too, and talk it up as much as possible. Okay, Jocelyn on YouTube has a question. What do we do if they haven't posted a rent increase for the year in Oakland, and we have to give a 60 days notice for a rent increase, and there's no answer from the RAP staff?
Well, I'm not sure I understand the question. I mean, the rent board's website, posts on there somewhere the annual adjustment and when it takes effect. And both San Francisco just not so recently now, a year or two ago, revised its website, and that was maybe, I think it was perfect because I've been using it so long. I knew exactly where to look for everything that I was interested in finding, and now I'm just like lost in the woods. And I think the Oakland Rent Board did a similar thing, but they have big like banners of sections. Eventually, if I spent more time on it, I think I'd get as comfortable with it as I was with the old one. I just don't spend that much time on it these days. But no, that annual increase, is published. I mean, it would be hard to imagine that it wouldn't be. So again, I'm not sure I understand that.
Did you say that it's published every August?
Yeah, no, it takes effect in August. When they actually put it out, maybe in June, July, that I'd be guessing. I'm not sure, but it is published probably in the spring. I mean, it's not published yet, or else we would have caught it, because as you saw from the presentation, it's still 2.3% from August of last year. So we don't have the August 24 rate yet, but it will come out. I mean. And you won't need a 60-day notice because that's for increases of over 10%. So you're not going to get 10% in any scenario that I can think of. And
is there
I guess the question was, we need to get that information in enough time to send a 60-day notice of rent increase, which means because again, any rent increase and this is maybe a little confusing. Your anniversary date is when the tenancy began, and that's when you can always annually increase. Like if a tenancy began July 1st, on July 1st of next year, you have the right to do a rent increase, and it would be for the amount that was in the rent board's website starting August 1st until July 31st of the following year. And you could, if you think you're going to get a higher rent increase because inflation has been more in that more recent year, you don't have to give a rent increase on your anniversary. You can wait a couple of months, see what that new adjusted amount's going to be. Maybe it's 5% or something. Well, they actually keep it at 3%, so I don't think it makes any difference, quite honestly. But yeah, you don't have to give a rent increase on the anniversary date. If you give a later one, like 2 or 3 months after your actual anniversary date, that becomes your new anniversary date. I hope that's clear. So,
So what was it for this last year that I know that it's been almost
I think in this presentation I just saw 2.3%. I mean, because again, I don't memorize these things,
2.3.
but I'm pretty sure that was what we covered in there.
All
I
right.
can
So
quickly look.
2.3, even though it may or may not be posted there, but somehow Sybil, one of your
Well,
associates.
again, this is the one that was, published for last year, but it just, yeah, so it's 2.5%. Let me, I'm not going to share screen. I'll just read it. Effective August 1st, 2023, the annual CPI increase is 2.5%. Now
2.5.
there's a link there, which I can click on right now and just see if it gives me more information about when that CPI announcement update. The City Council has adopted an amendment to change the formula used to calculate increase to 60% of the CPI or 3%, whichever is lower, effective August 1st. So yeah, so that's what Sybil, my assistant, took from the rent board's website and put in. It doesn't
So
say
it's going to
when.
be, it's effective from August 1st, 2023. So we can expect that to be the rate that can be used all the way up until August of.
Until July. Any rent increase that takes effect between August 1st of last year and July 31st of this year is for that amount. I'm just looking for the when they issue the. I'm actually looking at their website. My eyes are no longer staring at you. I'm trying to see if they tell me when they do the. And I think we covered that. There's still the last vestige of the whole pandemic moratorium stuff, is now, just as far as I know, in Oakland, which is to say the only rent increase you can do in Oakland until the end of July is the CPI increase. No substantial repair, capital improvement increase. So that's the last vestige of the moratorium provisions, which had been eviction moratoriums and some were rent increase moratoriums, but this is as far as I know, Oakland has the last one that finally expires. Yeah, I was just looking for when that, and it's not going to tell me on their little website when they issue the new one. So I thought I would be able to quickly get to that, but I'm not.
So Jocelyn's right in that, what's posted there is just from last year, and it's just because it's straddling the year that it's bringing a little confusion. So this is what was posted there from last year is good in 2024 up until the end of July, and then hopefully we can have a party.
Yeah, no, if they don't post a new one by June, I'll be shocked. We'll have this conversation.
Yeah, so I hear her to give enough notice. It's got to be what's going to be effective August 1st has got to be out at least more than a month before that, because you need to be able to prepare it and
I mean, you should have your notice ready, and all you got to do is put in the amount. I mean, basically, and then it's 30 days if you hand deliver it, and 35 if you mail it by. She can't just mail it. Notices of rent increase have to be served like either hand delivery or post and mail.
And then Jocelyn asked if we have to register rents as of August and they don't post until spring and the registry is due in March, how does it all work?
Well, I think you register whatever your rent is at the time, unless they're going to ask you, do you expect to do a rent increase? Again, I have not personally been in that rent registry, so I don't know exactly what they asked for, but I'm guessing it's similar to what they describe it, which is the property address, the ownership, the current tenants. I don't know if they require the identification of the tenants, but when they moved in, what's the current rent? Maybe I should go through there, but something tells me I also have to, have property register and all that, and I just don't in Oakland. So I'd be happy to have somebody take me through the experience of having gone through the rent registry.
Mm-hmm. Mm-hmm.
Although we could do it right now and share a screen, shall we?
Well, yeah, I mean, you can. I don't, how to get there, I guess.
I mean, let's see. Hold on one second. So the rent board. This could be kind of interesting. Okay, I'm going to share my screen with a website I'm on. And let's see if we can do this together. So this is the Oakland, this is part of the Oakland Rent Board website, housing laws and regulations, because I've already clicked from the main. So here's sort of the main page, the rent adjustment program, which is really the rent board's website, and so you can find this quite easily. It's got little sidebars, but basically, there's your thing about the rent increases through June 30th. Yeah, so not July. That's the December city council. That's what I'm saying. If you follow this, you can actually stay on top of things. December approved the ordinance and regulation amendments. So we talked about that. And here's your rent registry ordinance. That's the one that basically says you now have until July. But let's go to the reg. I want to see if we can register. CPI announcement. Oh, okay. Well, no, that is so they'll just do it. The CPI announcement will just say effective August 1st, 2023. The new annual increase is X. Again, when that comes out, I just don't know. Here's live counseling sessions for the rent registry. So that's something, again, their seminars, their online seminars, I think are probably worth finding out. So
there's the rent
updated
registry.
forms, advisory notice due to the rent registry. They're now outdated forms. Property owners and tenants should use these updated forms, right? So this is the, let's just see. Adjustment program forms and notices. So, yeah, so these are basically the current forms.
Yeah. And then right underneath where you just were, it looked like it had the rent registry.
Oh, okay, let me move that thing out of the way. Okay, rent registry. Shall we go there? All right. And I'm not really sure about the screen sharing. Are you following me? I'm now welcome to the City of Oakland Rent Registry. Are you following me there?
Yeah, we can see it.
Okay. Because again, sometimes it doesn't follow. So I'm always a little bit. So rent registry info, user guide, create. This is what I'm pretty sure create an account.
It might take a little longer than.
Yeah, well, that's what I'm saying. I don't think there's a user guide, rent registry info and facts. Let's see, what does it actually ask for? Registration, register online.
There's the registration form next to it. So the form would show what's
up. Now we're back to square one there. Registration forms. Yeah, let's see if we can figure out what do they ask for. So owner's man must complete this for each unit. Okay, Tennessee. So unit, of course, total number, etc. Initial registration. Have you done that? Yeah, done that. Rent and occupancy, tenancy start date, number of occupants. Yeah, they don't want to know who's there. They just want to know what's going on there. Security deposit, housing services provided. So yeah, interesting. I'm curious now to find out if I can get these records. I mean, I'm sure I can, but they do want the tenant. Oh, I am, a little surprised about that, but maybe not surprised. Prior tenancy information. Well, there you have it. I don't know if that answered the question or not, but to the extent that, yeah, you have to do that and you get in trouble if you don't. So, and that was we talked about this, I think last year, Alameda County, which encompasses, the whole East Bay, basically. Oakland, obviously a part of the Alameda County, was trying to enact rent and eviction control for the whole county and a rent registry. And that failed to pass the Board of Supervisors like 3-2 or something. So, they're always out there, trying to do stuff. So got to stay on top of things.
Right.
Well, how's that?
Great. Well, thank you for taking the time.
Sure. Like I say, it's good for me because, I refresh my recollection about some things. I learned some things, my associate gets, more informed of me. So thank you for the opportunity, Jeff.
Let me see. Okay.
Trying to squeeze one more in.
Yeah, just reading everything here. Okay, great.
All right. Time for lunch, I think.
Yeah, it's time to get lunch. So thanks again, Rich, for coming on the live stream, and then we look forward to seeing you hopefully in August. Hopefully we'll have it in person.
Yeah.
And if you're around or not, or whether it'll be somebody else leading the way, we'll find out.
All right. Well, I'll see you before August, I'm sure.
Okay, sounds good. Thanks, everyone.
Bye-bye.